You know in the movies when a lawyer dramatically says, "The prosecution rests," it's supposed to mean they're done, right? Case closed. But what if it's not? That's what we're diving into today on The Explainer. The incredibly rare, super high stakes moment when a lawyer gets the last word after everyone thought the talking was over.
Okay, put yourself in this situation. You're the prosecutor. You've laid out your entire case, piece by piece. You've wrapped it all up and you confidently tell the court the prosecution rests. And then, bam, the defense calls a surprise witness who drops a bombshell alibi, something completely out of left field. Is that it? Is your case just gone? Or do you get one more shot?
So how does this all play out? Here's our game plan. First, we'll cover the basic rule. When your case is closed, it's closed. Then we'll get into the unexpected twists that throw a wrench in the works. We'll look at the specific rules for a rebuttal, the tough test a judge has to apply, and finally, we'll talk about why this is all about one big idea: fairness.
All right, let's get right into it. The first thing you have to understand about a trial is its structure. It's built on a really simple, orderly principle. Each side gets one shot. The prosecution presents its case, then the defense presents its case. That's it. This structure is absolutely fundamental to how our system works. And there's a really good reason for this structure. It's to stop something called splitting your case. Think of it like this. It's basically holding a trump card up your sleeve. A lawyer might be tempted to keep a key piece of evidence back, just to see what the other side does, and then, wham, play their secret weapon at the last minute. Well, the rules say absolutely not. That's a major no-no. You've got to lay all your cards on the table from the very beginning. So it's really important to see the difference here. On one side, you have splitting your case, which is basically a forbidden tactic, a strategic game the court won't allow. But on the other side, you have what we're talking about today, evidence in rebuttal. And this is totally different. It's not a do-over, it's not a second bite at the apple. It's a very rare, very specific tool used only to answer something brand new and completely unforeseeable. Okay, so what does happen when that genuinely shocking moment hits? When the defense pulls something out of thin air that completely blindsides the prosecution? Let's jump back to our surprise alibi. The defendant hasn't said a word about where he was, and then suddenly, a witness appears on the stand and swears he was 100 miles away when the crime happened. I mean, this is a direct shot at the heart of the prosecution's case, and it all happened after they thought they were done. So, are they just stuck? Powerless? Well, the answer is not always. The court does have a special power to let the prosecution fight back, to call a new witness or show new evidence to challenge that alibi. But, and this is a huge but, this power is used, and I'm quoting here, very sparingly. Think of it like a big red emergency lever behind glass. It's not something you use every day. Okay, so if it's an emergency lever, what exactly counts as an emergency? Well, a judge can't just decide on a whim. Their decision is guided by a really specific set of rules. So when would a judge actually break the glass and pull that lever? Well, there are a few classic situations. That surprise alibi we talked about? Yeah. If its nature was truly impossible to predict, that's a big one. Or let's say the defense suddenly starts talking about what a great guy the defendant is. Well, that opens the door for the prosecution to introduce evidence to the contrary. It can even be for something small, like fixing a minor technical error, or maybe for a crucial piece of evidence that was genuinely, physically unavailable until that moment. So you can see the big question for the judge is all about foreseeability. Could this have been seen coming? And how they answer that question, well, that has actually changed quite a bit over the years. The old test was, honestly, almost ridiculous. The bar was set at something which no human ingenuity can foresee. Think about that. You'd basically have to be a mind reader or a fortune teller. It was more of a grand rhetorical phrase than a practical legal rule. I mean, the bar was so high, it was pretty much impossible for anything to get over it. Thankfully, today's test is way more grounded in reality. The judge now asks a much more sensible question. What ought to have been reasonably foreseen? See the difference? It's not about being psychic anymore. It's about being prepared and diligent. So, if the defense hinted at an alibi weeks ago, the prosecution can't claim to be surprised now. They had their chance and they're not getting another one.
All right, this brings us to the final, and honestly, the most important part of this whole discussion. Why? Why are the rules so strict? Because this isn't just about keeping the courtroom schedule on track. This gets to the very heart of what justice is.
I mean, you might be thinking, isn't the whole point to find the truth?
So why not just allow any evidence at any time if it helps get us there? Why bother with all these rigid procedural rules? And the answer comes down to one single powerful word: fairness. This quote from Justice Dawson says it all. The accused is entitled to know the case which he has to meet. You can't ask someone to defend themselves if they don't know exactly what they're defending against. It's that simple.
And this idea of fairness isn't just an abstract concept. It has huge practical consequences. First, it prevents what's called a trial by ambush. It guarantees the accused person can actually prepare a real defense. It also stops trials from becoming these messy, chaotic, endless affairs. And, maybe most importantly, it prevents a single dramatic, last-minute piece of evidence from unfairly swaying the jury just because it was the last thing they heard.
So, when you look at it that way, this strict rule against splitting a case, it isn't a bug in the system. It's a feature, a critical one. It's there to protect the entire structure and, most importantly, the fairness of the trial process. But this does leave us with one last, tricky question. The rule is all about fairness, but could it ever be too strict? Could there be a moment where following the procedure to the letter actually gets in the way of finding the truth? It's a really tough balancing act, and it's why a judge's decision in these rare, high-stakes moments is just so incredibly critical.